Welcome back, everyone. A federal high court in Abuja has convicted Nnamdi Kanu, leader of the indigenous people of Biafra, IPOB, on all 7 terrorism-related charges brought against him. Justice James Omotosho ruled that the prosecution presented incontrovertible evidence, including video and radio broadcasts, showing that Kanu incited violence, enforced sit-at-home orders, and gave instructions linked to bomb making. Kanu did not open his defense. The court said he deliberately refused to counter the prosecution's case. And under the Terrorism Prevention Act of 2013, Section 16, the judge noted that the offenses he was found guilty of carry life imprisonment or death. This conviction marks a significant moment in the long-running and deeply contentious legal and political saga surrounding Biafran separatist movements. So let's have this conversation tonight. Joining me for some legal perspectives, 3 gentlemen. Tony Daniel is a lawyer, and he would be joining us in the course of the conversation. Kabir Akibuli is also a lawyer and political affairs analyst. And I also have Olayinka Ola Daniel, also a legal practitioner. Both of them are joining me virtually. Gentlemen, good evening to you. Thank you for joining us on Politics Tonight.
Good
Mr.
evening.
Ola Daniel, are you there? Let me start with you,
me.
if you can hear me. So Mr. Kanu has been sentenced to life imprisonment, but well, for the purpose of some of us who are not lawyers, perhaps we should start from the legality of the status used. On what legal basis was he charged, and under which terrorism status?
Don't forget that we have what is the law called now? We have the Prohibition Terrorism Act of 2022. In fact, it was 2011, so it was repealed, and we have the act in 2022 that gave rooms for such judgment. So Kanu was not just tried in abeyance; it was tried under the law of the Federal Republic of Nigeria, which is the Prohibition and Terrorism Act of 2022. So the law subsists, and he has a case to answer. And he has all the time. The court was magnanimous enough to give him different time to open his defense. But Kanu refused. He even sacked his lawyers, thinking maybe he knows more than the lawyers, so that he could do it himself. Probably he did not know the extent of the crime he has committed. Perhaps he does not even think that he has committed any crime. And that is why he was telling the court that the court does not, the court doesn't have jurisdiction to try him, that the court has no law, that there's no law that says, that gives the court power to try him. And I ask, where did that come from? So, meaning that, is it that he was not properly advised, or he was advised and he was not ready to listen to his lawyers? Because if he listened to his lawyers, it's simple. There's a law in this country. Prohibition on Terrorism Act, there is a law in this country. And if you have heard and you have done anything against the law, then you should be able to face the music. And he has all the opportunity in this world to defend himself.
Well, Mr. Daniel, his defense argues the court prosecuted him under a repealed law. And, you know, I've been wondering since that court sentences came in, how strong is the constitutional argument that a court cannot convict under a statute that is no longer in force?
No, don't forget that there is a 2011 and we have the current 2022. That law, yes, that law has been assented to in 2022. So they cannot say that law does not exist. You cannot say that law does not exist. There is a law. There's a statutory law that gives provision for such criminal matter. This is terrorism we are talking about here. You cannot say there is no statute that gives rooms for terrorism that gives rooms for courts to try terrorism. There is. So I don't know where that, I don't know where the argument of, oh, no subsisting statute,
All
so
right.
therefore it cannot be tried.
All right, then. I'll come back to you. Mr. Kimbulu, can you hear me? Good evening to you. All right. Guess it's not there. Let me continue with you, Mr. Daniel. One other thing that, his legal team had said is that, they were contending that his extraordinary rendition from Kenya violated both Nigerian and international law. And Justice Omotosho said there was no evidence of an extraordinary extradition, and that the manner of which Kanu's return to Nigeria didn't invalidate the trial as he had claimed because he had jumped bail. He's insisted, I'm talking about Kanu now, Kanu insisted that he didn't jump bail and shouldn't be detained under non-existent law. What is the full legal reasoning behind the judge's conclusion?
Well, unfortunately, under our law, it is clear. See, illegality. That means how, in as much as I'm also of the view that, oh, yes, it was picked up in Kenya, it was illegally picked up in Kenya, and it was bundled to Nigeria to answer a case. In as much as some of us, were against this. However, illegality in Nigeria does not make you escape a criminal matter. Once it's a criminal case, you can't say because, the way you were brought in was illegal, therefore you don't have a case to answer. There is no position for such law under our law. So whether anyhow you were brought to Nigeria, you have a case to answer under our law. Yes, maybe the way you were brought in was illegally obtained. Like we all know, we've been following the case that says, okay, it was bundled from Kenya. Even the Kenya government was saying, okay, yeah, everybody taking blames here and there, but does not invalidate the prosecution of Kanu in Nigeria under our law.
All right. Let me hear from Mr. Tony Daniel. Thank you very much for joining us on the program. So, Nnamdi Kanu has been sentenced to life imprisonment, and just the question I asked him, his legal team was contending that his extraordinary rendition from Kenya violated both Nigerian and international law, and he was insisting that he didn't jump bail. But what constitutional issues, does this raise about Nigeria's jurisdiction to try him? Does jumping bail automatically remove the right to challenge how he was returned? Is the judge saying that because bail was jumped, or is there any legal argument that was weakened?
The fact that he jumped bail, there are consequences. That has been taken care of, and it does not in any way raise any constitutional issue. If someone jumps bail, it will be difficult to get bail again. It's not that it will be possible. It depends most often on the allegation for which the person is charged. So the fact that he jumps bail is bad, it's improper, but it does not affect trial. Then secondly, the fact that he was, irrespective of how he was brought into, or how he was rearrested, as far as he has been rearrested and he has been brought to the country and he faced trial, that also does not raise any constitutional issue. Of course, he has his right to movement as provided in the Constitution. He has his right, but you see, other persons also have their rights. Nnamdi Kanu was associated with, this is a sensitive issue, was associated with a lot of criminal activities. And then nobody expects the federal government to fold its hand and allow that. We tend to forget things too easily in Nigeria. I remember the atrocities. And when he was first arrested and brought to court, he was granted bail. It is no longer news that he jumped bail. Then he engaged a lot of lawyers. The trial, there was fair hearing as far as I'm concerned. I'm in practice. There was fair hearing. Honorable Justice Omotosho gave room to Nnamdi Kanu. And then I think he became highly emotional and temperamental, and he sacked all his lawyers and said he wanted to defend himself. I gave my opinion, advised him to re-engage his lawyer. He had a respected lawyer in the person of Agabi, and we thought at least he would have retained that lawyer. He keeps saying that the law under which he was charged has been repealed. No.
Yes.
There's always, if a law is repealed, particularly this law, the Terrorist Prohibition Act, you know, we've had it from 2009, 2013, and 2022. There is always this saving section. It is there in the 2013 when the 2009 Act was amended. It is there in the 2022 Act when the 2013 was repealed. I deliberately brought it here. It is section 97 of the Terrorism Prevention and Prohibition Act 2022.
All right.
Section 97 says, the subtitle is Savings and Transitional Provision. Any regulation, order, requirement, certificate, notice, direction, decision, authorization, consent, application, ongoing cases in the court, requests or thing made, issued, given or done under the repealed act or amended sections shall, if in force at the commencement of this act, continue, that it shall continue to be in force and have effect as if made, issued, given, or done under the corresponding provision of this act. What it means is that if your trial have started before the commencement of this amended act, it will continue.
Okay.
So, and you know, ignorantia juris non excusat, ignorance of the law is not an excuse. So when Nnamdi Kanu decided to take his bail, handle his trial, his defense by himself, I have given my opinion on it, widely publicized, that it's making progress in error.
All right.
Yes.
He had no
and then,
case.
you know, apart from the sections or the laws under which is charged, apart from the Terrorism Act, he was also charged under the Criminal Code.
Okay.
You know,
Right.
Section 41.
We'll come back to that, Mr.
Yes.
Daniel. Section 41, we'll come back to that. Mr. Akibolu, let me bring you into this conversation. What's your first reaction to Justice Omotosho's judgment? And, you know, they say clearly an accused person is, you know, perfectly entitled to dispute the jurisdiction of the trial court. But does that challenge suspend the requirements to elect, you know, one of the lawful procedural options available after the, you know, close of the prosecution case? And what is the proper approach? All right, we'll come back to Mr. Akibolu. Please go on, Mr. Daniel.
Yes.
You were talking about the Criminal Code Act.
Yes, the Criminal Code Act, Section 41, is here, under which he was charged under Section 41, Paragraph C. He said, any person who forms an intention to effect any of the following purposes, that is to say, we'll go to Paragraph C, to levy war against Nigeria in order by force or constraint to compel the president to change his measures or counsels, or in order to put any force or constraint upon, or in order to intimidate or overpower any house of the National Assembly or any other legislature or legislative authority, or, and I said, the penalty is life imprisonment.
All right.
Yes.
Mr. Laika Daniels, let me come to you now. Kanu has argued that, you know, some of the counts amounts to double jeopardy because they allegedly overlap with counts that had been struck out earlier. And I mean, from your own perspective, what counts was he referring to?
Well, really, I do not know the count Kanu was referring to as to counts that have been overlapped, previously, and that should not be part of the new camp because this matter came up in court. Your lawyers were doing a good job, and if your lawyer had entered defense, if you had allowed your lawyer to do their job, perhaps the story may be different. Perhaps they will identify some of those things. What you don't know about, you want to do a macho to say that, okay, so what is the job of a lawyer?
But he has a right to defend himself.
You know the law. So, yeah, absolutely. Everybody, the Constitution made provisions for that. You have a right to defend yourself. But to what end? Are you versed in what you want to defend? Do you know the implication of what you are doing? This is not a civil matter. That, okay, you can say you want to go to court and say stories. There are technicalities in this matter. This matter, I'm always careful because it's a sensitive matter, but then we just have to say it the way it is. So what you don't know much about is something you know that can sentence you to death. It can give you death sentence. It can give you life imprisonment. Then you want to play with it. Then you want to say people like Kanu Agabi, a senior advocate, a well-respected lawyer, doesn't know what he's doing.
All right, Mr. Daniel, because one of the kindly holders are one of the most potent ground of appeal in a criminal matter is lack of fair hearing. Can Nnamdi Kanu allege that?
How can Kanu come to say there's no fair hearing? Kanu was given, or in fact, like I said earlier, the court was magnanimous. He gave Kanu, in fact, each time Kanu comes to play some games, today's story, another one, another story, the court kept adjourning, giving him enough time. So Kanu had fair hearing. The principle of fair hearing has not been violated in any way. He did not maximize it. He didn't use it. He had it. And the court has said, look, by next adjourn date, if you don't enter your defense, if we don't have anything, it means that, sorry, I have to give judgment. We're not going to leave this because you think, you are not ready to enter your defense. And we all know the provision of the law. If you sleep on your right to defense, so what will the court do?
All right.
The court will close the case and give his judgment, and that's what has happened. So the court has not violated any fair hearing, any rules of fair hearing, no, any principle of fair hearing. The court has not violated any. Kanu had all the time, but he refused to defend himself. All
right, I'll come back to you, Mr. Daniel. Let me come back to the studio. A legal team that had people like Gabi SEN, that had Ipiazu SEN, Ozekome, Etiaba SEN. I mean, he decided to disengage this team at a point that mattered most in his trial. Like I said to him, I mean, one of the most potent ground of appeal is lack of fair hearing. Can he allege that?
Well, like my colleague stated, he cannot.
At all?
He cannot because there was fair hearing. He started acting in error, thinking that what you need to do is to assert your ability to apply force, to talk loud, to insult the presiding judge. You know, judges are not supposed to show emotions, but they are humans. If the judge has shown emotion, people like us would have criticized him that if you know you are no longer comfortable with the case because of the fact that you were insulted, you return the case file to the CJ of the Federal High Court, who will now reassign it to another judge. But we saw the calmness with which Justice Omotosho took all the insult, the vulgar abuse, the misbehavior in court. If you do that, you know, you can be taken in for contempt in the face of the court. And the judge have summary jurisdiction, have power to penalize you. But we saw the calmness the judge exhibited. So Then he gave time to Kanu. Kanu was saying, you can't hear me. This law is repealed. No, that's not how to do it. There are procedures.
What are the procedures?
If, for instance, you have any reason to contest the charge as is, you file a preliminary objection. You don't go and say, no, you don't do that. Assuming without even conceding that, yes, Kanu has a good point. That is not how to do it. Don't forget that he had previously filed a no case. His lawyers filed a no case, which means, assuming we take it that all that the prosecution has said is true and correct, they are not enough for me to come and enter my defense. That's the meaning of a no case submission. But the court overruled it. That is, refused it. So you were now supposed to open your defense. Instead of opening his defense, Nnamdi Kanu decided to sack all his lawyers and said he would now want to represent himself and was carrying law books. He has a constitutional right to represent himself. Yes, but he is not a lawyer. He might not be able to do some of the things his lawyers would have done. You understand? So it's unfortunate, but I want to commend the judge because, you see, the society must exist before you apply law. It is not the other way around. The law is meant to govern the society, not society governing law. So we must be alive. We must consider peaceful existence and all that. The implications cannot be predicted. But we've been seeing agitations that, oh, let Kanu go. And my opinion is that I never supported the protest called. I discovered that we don't know how to really manage protests. As a student, I was an activist and I managed protests.
All right.
The first, look at the endsars. It's an experience that drags you off. But you see, we have been protesting in this country technically without disrupting anything. Ask me how. Recall when the president granted pardon. It was on phone. Everybody started. That is protest. That is an effective protest. And the president started reviewing his position. We've seen things play out like that. And I've been preaching that we have this phone. You can protest through your phone. When any issue goes viral, look at the confrontation, I don't want to go into that, between the FCT minister.
All right. All right, Mr. Daniel, I do apologize. Can you hold your thoughts? Let me bring in Mr. Akimbolu into this conversation. Mr. Akimbolu, can you hear me? So what's your first reaction to Justice Omotosho's judgment today?
Myself?
Yes, Mr. Akimbolu, go on, please.
Hello?
Yes, please go on.
Yeah. Well, I think we must commend the judge, for a job well done. And the judge exhibited one of the rarest characteristics of a judge, that is not being provoked in the face of the greatest, insult and vulgar abuses and all that. He constricted himself into law. You understand? He restricted himself to law, and he did just that. The issue of fair hearing, I think, is just like a drowning man holding to any straw. I don't think they can raise it. The whole principles of fair hearing dies at being given the opportunity and you fail to utilize it. He has all the day, he had the day in court, he refused to utilize the opportunity given to him to be heard. And if you have been given opportunity and you say you didn't make use of it, you will not be hard to say my right to fair hearing was violated. And let me say this, I think is one offense too many, or one suspect too many, or one accused person too many. The way he conducted himself in court is too funny, and I think even some of our colleagues that handled the matter did not even, I don't think they have assisted him. In a situation, your client will be insulting you, shut up, you don't know anything, don't talk to me, all those things. We have a profession that has a culture. A client cannot, you are the dominant litigant of the case you are handling. A client has no right to talk to lawyers like that, but they condone everything. I don't know what it means or what it could be. In fact, most of the lawyers, I think they tried also, even they ought to have walked away before he eventually sacked them, but thank God he sacked them because they have not upheld the principle or the ethos of that profession. The profession, I think, was breached seriously. And but coming to the judgment, I was even expecting death sentence, but then I think the reason given by the judge is something to think about, something to reason for, that the issue of death sentence is fading out in the outside world. But whether we like it or not, it's still part of our law. If you read the Holy Bible, you read the Holy Quran, it's an eye for an eye. We know how many people who are victims of his nefarious criminal activities. We know it very well. People will say, oh, you don't talk, but the evidence is there. So it's not anything, and thank God we can say it now because the courts came to a conclusion, they have convicted him. I think this should serve as a lesson to some people who think they can become lawless and commit criminality, taking that will lead to loss of life. Thank God his colleague in crime, his partner in crime in Finland, is already serving, I think, 6 or 7 years in prison, some EPA, and unfortunately he says he's a lawyer. So I think it's a very good judgment. It's a very sound judgment. I don't expect anything less.
All right, Mr. Akigbolu, does the law provide a case for mere puffery, mere speeches, empty threats? Because after he was sentenced, I heard his consultant, Aloy Ejimako, I mean, he says Mr. Kanu was just talking, and he attributed his words to words like somebody saying, "Don't be silly." So as a lawyer or lawyers, does the law accept mere puffery? What provision of our law accepts that? Mr. Akigbolu, before I come back to this
for somebody to talk after the court or what?
All right, I'll come back to you. Did you get that question?
Yes.
Okay, please go on.
There's nowhere in the law where you can find that justifiably. And I think, as a psychologist, that there's some issue of partial neurosis. This is somebody that is used to commanding people, that used to instill fear, is kept incapacitated for so long, he became more like frustrated, and I think some issue of depression came in. If you look at his attitude, the way he was boastful, the way he was talking, it's like when a man just joined the secret court, he will have this Dutch courage. You see him talking to those who are his senior without respect. So there is nowhere in law where that comes in. Except if I don't understand your question.
Yeah, that's it.
Good. There's nowhere in law that you can justify that. He has a right to file appeal. Again, the penalty for 1 or 2 of the counts in the charge is death sentence. That has been commuted to life imprisonment because of the allocatus, the plea by the other lawyers. I don't know the lawyers because I thought he was not having any lawyers, but I saw some areas of lawyers there on the TV. So he has a right.
And they stood as consultants and representatives.
It's okay. He has a right of appeal. He can go and file appeal if he's not satisfied. And then I learned, I don't know whether it is true, that he has made administrative letters to the Chief Justice of the Federation. This case does not concern the Chief Justice of the Federation.
All right,
it's Federal High Court.
All right. Let's take a break, Mr. Daniel. And when we return, we'll continue this conversation. Please stay with us, everyone. Thank you for staying with us, everyone. Nnamdi Kanu sentenced to life imprisonment, and I've been getting some legal perspectives from 3 lawyers, Tony Daniel, Olayinka Ola Daniels, and Kabir Akigbolu. Gentlemen, thank you very much for staying with us on the program. Mr. Olayinka Daniel, let me come to you. The judge in his case reportedly said, can you hear me, Mr. Olayinka?
Yes.
All right.
Very well.
Right. So the judge.
I can hear you very well.
All right then. The judge in his case reportedly said that the rights to self-determination must be pursued within the bounds of Nigeria's constitution. What are the constitutional limits on self-determination in Nigeria?
Well, the part of it is the cases that we are going through at the moment. You can't instigate people. You can't say, okay, self-determination. Yes, you can. You can write to the National Assembly. You want to go, you can do, but you cannot go beyond. You can't do. You can't be an accessory for any incitement. You can't say you're looking for self-determination. Then what you are doing is telling people to go and kill people. Is telling people to shut down the whole country, to shut down and calling some country or some people names. No, that is not the procedure. That is not the way to go about it. You can have a memorandum. You can, the local government, the state, okay, for instance, we have how many states in the Southeast? If all of them, agree to it, what stops all the states from putting up, through their House of Assembly, all of them, they send their whatever to the House of Assembly. House of Assembly, all of them look at it together. If they agree, they come together. They have 6 or 7 thereabout states. They can come together and then proceed to National Assembly. Proceed to National Assembly. Let the National Assembly give it a thought. Look at it. If it flies, you can have a memorandum. They can sit. We can, call all stakeholders. And right. If they, with all the federal government, if all of them come together, okay, this is the reason why we need to go. This is the reason why we.
Let me see if your colleagues agree with you, Mr. Kibolu. If you can
remember what also.
All right, Mr. Kibolu, if you can hear me, can calls for secession ever be considered a legitimate expression?
Before he was called to order. And if you remember also, they went for him to arrest him. He ran, but, let's leave his story. Let's take with Kanu.
All right, Mr. Kibolu, let me come to you now. Can calls for secession ever be considered a legitimate expression under Nigerian constitutional law?
Just like Mr. Oyedeyin, my learned friend, has said, there is a procedure, or there are procedures. You do referendum, what they call referendum, people sign, okay, this is what you want. The people they will lay their claim before their wishes or their demand, the way they want to go, in a peaceful way, in accordance with the law. You cannot just take law into your hands and say, oh, kill him. Do you know how many policemen died? Do you know how many stations, television, and whatever stations that were burned? Do you know how many BRT buses that were burned in Lagos? Do you know how many people that were killed in the East? In the 5 states, the sit at home in the East is the one that brought it alive. And it's still there today, people are still suffering. So in this kind of thing, a situation whereby you are mobilizing people against the government, it's treasonable felony. When you are in a way, if you move away, and you must have supporters, if you have had supporters or followers, those who believe in your ideology to secede, then it's treasonable felony. Or if you have conducted yourself in such a way that the commander-in-chief can be forced to order his troops to fight, then you have committed treasonable felony. So all these offenses have been committed by this guy. And unfortunately, it's not remorseful. In fact, there is no military factors that can reduce the sentencing, but the judge was very magnanimous. You understand? We have one unified Nigeria. If you want to go, you can only go in a peaceful way. Because if the law is given to everybody to just say, oh, I'm tired of this country, I want to go, then Nigeria will not be at peace. So if you do anything outside this to make Nigeria divisible, you have committed an offense. And this is exactly what has happened in this case. And I think the end of justice has been met. We thank God. Only that it is not, I frown at the way the justice delivery system has been delayed. However, the judge said it was the Kanu that delayed the trial. If that is so, fine. But if it's not coming from him, it is not too good. But justice has been served.
All right, let me come back to the studio, Mr. Daniel. The implication of this judgment on the Southeast, politically, economically, socially.
You know, so many persons in the Southeast are afraid to speak out. The truth is that they went through a hell of an ordeal. And most of the very bloody incidents, illegal incidents, killings, maiming, gangster administration of certain local government within the Southeast were associated with Nnamdi Kanu. I just remember a horrible scene. I can't take my mind off. The soldiers, they were butchered alive, husband and wife, they are Igbos. So some of the governors were beginning to bow for Nnamdi Kanu. He was becoming like the commander in the Southeast. I am very sure some persons will be happy, particularly those, because the havoc was not only against non-Igbos. It was really the Igbos that suffer it most. And if you look at, they have analyzed the losses of this sit-at-home every Monday. And they are still suffering these losses. Nobody is making it up. So, and then when you give such order and you follow it up with action, that is treasonable felony. Every citizen has a right to denounce your citizenship peacefully under the Constitution. And you go. That is why dual citizenship is allowed. You can become a citizen of America, of anywhere.
All right.
Now, if you're no longer interested in becoming a citizen in Nigeria, there are procedures. You file appropriate application, do the necessary affidavit, get a pronouncement that you have ceased to be a citizenship. Nobody will fight you. But where you make laws of your own, set up armies of your own, commander this army to hurt people. The federal, first of all, Section 1 of the 1999 Constitution says the Constitution is most supreme. Then the Constitution taxes the government to protect lives and property. They are supposed to protect our lives and property.
All right.
And that's where, when such rights and property, lives and property, is threatened, the government must intervene. And since it is the federal government that controls the police and the military, the president is the commander-in-chief of the armed forces. He will approve the required force with which to bring sanity to that place. So I'm very sure that politically, there will be disquiet in the Southeast. Fortunately, the judge did not apply the maximum sentence of death. It's life imprisonment. So he's still alive.
All right, then. I want to deviate a bit, and I wish I could take the submissions of the three of you, but sadly I cannot. So let me go to Mr. Kabir Akinwulu. I'm sure you all must have been following the U.S. Congress hearing, public hearing on alleged Christian genocide in Nigeria. Mr. Akinwulu, are you there? What's your submission on this, and what do you think we need to do here in Nigeria?
Well, what we need to do is to place enough premium on the lives of the citizens. I want to tell you, the question to ask ourselves is this: is there security in Nigeria? No. The answer is no. Is there genocide in Nigeria? Yes. Is there genocide against Christians? No. There's genocide generally. There was a time in Kanu when they entered the Emir Mosque and killed over 300 people. They are not Christians. On a Friday, there were places where people are calling people to prayer, they kill them. The people that were abducted in Kebbi recently, they are not Christians. Most of them are not Christians. So the Chibok girls, most of them are not Christians. So why are we now trying to micromanage this issue, or, put it in a small prison so as to be sentimental? There is serious genocide in Nigeria, but government should be frontal. They must attack it frontally. Then again, I think there should be special court for terrorists so as to deal with this thing expeditiously. Otherwise, we may be here for a long time.
All right, anything to say in 30 seconds?
Yes. The There is no genocide against Christians. The genocide is against Nigeria. That has been my take. But we need the kind of technology countries like America has to fight these people who don't have it.
All right. Mr. Oladaniel, 30 seconds, please.
I concur with my learned colleagues on genocide. It's not about Christian, it's genocide against Nigeria. And all I ask for is the willpower by the commander-in-chief of armed forces. The willpower. We can do it. We can do it.
All right.
We go outside this country and we know the awards our military personnel get. So in this country, we can do it.
Thank you, gentlemen.
We only need, Mr. President just need the willpower to kickstart this whole thing.
All right, thank you so much, gentlemen. Tony Daniel is a lawyer. Olayinka Oladaniel is also a lawyer, and Kabir Akibulu is a lawyer and political affairs analyst. Thank you so much, gentlemen, for your insights on today's conversation. Thank you so much.
Thank you.
Thank you.
And thank you very much for watching, everyone. That's our time, and that marks the end of today's episode of Politics Tonight. But before we go, let's tell you that the views and reactions of our resource persons are theirs and have no connection with TVC News. Meanwhile, you can watch the repeat broadcast of this episode at 12:30 a.m. Get in touch with us on our social media handles, Facebook, Instagram, and X at TVC News NG and at Olajumoke using the hashtag Politics Tonight. But also on YouTube at youtube.com/TVC News NG. I am Olajumoke. Good night, everyone. I'll see you again tomorrow.